Hi, I'm Angelo, Mena. I'm from Alexa Real Estate, and today we're going to be talking about commercial law. Being in real estate, we've seen firsthand how life-changingly catastrophic things can get when commercial agreements aren't put in place, when deals are done on a handshake and the appropriate paperwork doesn't accompany those handshakes. Today we're going to be speaking with Lucy Richards from Richard and Evans Commercial Lawyers. Lucy's had many years of experience in commercial law, and she's going to tell us some of the things we need to look out for when entering into agreements. Thanks so much for making the time today, Lucy. First of all, can you tell us a bit about yourself, and then can you tell us what we need to know about commercial contracts?
Thanks for the opportunity to come and talk with you today. My background is as a commercial lawyer in Adelaide for nearly 20 years. Our practice is Richards and Evans Commercial Lawyers, and I work with my husband Tom, who is also a commercial lawyer. One of the key themes in all aspects of the work we do is the importance of getting things recorded in writing rather than just having a handshake deal. There are so many times when clients have come to us and asked for help in trying to unpick a dispute where they say the deal was one thing and the party on the other side says the deal was something else, and it really then becomes a question of he said, she said, and how good is the evidence and who is more likely to be believed if it goes to a court. The benefit of getting legal advice at the beginning of a contract negotiation, and more importantly getting the contract itself recorded in writing, is that you can have someone with expertise write an enforceable contract that will deal with things that probably you haven't thought about or turned your mind to, or the other side has turned their mind to. And so there are all kinds of things that will go into a standard form contract to make it clear, to make it enforceable, and to hopefully avoid these kinds of disputes happening later on when the parties have a different viewpoint about what they really intended. I've acted for a number of people who have lent money, for instance, to a family member, and because it's a family member, there seems to be this perception that it can be done informally. In many ways, family relationships are the kinds of relationships where there's even a more important dynamic to justify having a written contract, because the family relationship shouldn't be disrupted by something like a loan agreement that goes sour. I've had parents who've lent money to their kids, quite significant sums of money, 100 grand, 200 grand or more, and often that's used for the kids to buy their first house, and that may be with a girlfriend or boyfriend at the time. And it's all good while the relationship's going well between the boyfriend and girlfriend and between the child and their parents. But if there's a fracture in any one of those relationships and the house needs to be sold, that can be a very messy knot to untangle about where that money goes back to. And I've acted for the parents in those types of situations. I've acted for the kids in those types of situations, and it's never easy. The other thing to bear in mind is that the legal costs of trying to unpick those sorts of problems vastly outweigh the costs of getting it drafted correctly at the beginning. It's a quicker process, it's less stressful, it's peace of mind, and I would encourage people to think about getting a lawyer involved early and getting the documentation right, rather than finding themselves in the unfortunate position of having to go and see a lawyer when things have gone wrong. Another area where I think people sometimes resist the idea of getting a written contract is when you have two people who come together to form a new business. They might be friends or colleagues, and perhaps cash flow is tight, and I understand that the idea of shelling out some money for a joint venture agreement or a partnership agreement, or whatever it might be, is perhaps not the kind of thing they want to be doing in those early days. What I've seen though is those people that don't spend the money recording the terms of the business arrangement at the beginning can run into enormous difficulty later on, where things have become successful. They never really got around to recording the terms of the agreement in writing earlier on, and now there's actually a lot more at stake. And unfortunately, business partners can fall into terrible disputes with each other about really key things like control, decision making, spending money, the direction of the business, all of that sort of stuff that if you can deal with it at a time early on in the business, when perhaps emotions are not running quite so high and there's less at stake, you can actually have a nice, simple agreement that records these sorts of things rather than have to come back and have a fight about it later on because you never got around to recording it in writing at the right time. Although it's really important to have well-drafted legal documents recording business contracts and family agreements, sometimes legal disputes are inevitable, and that might be because of a misunderstanding or some complexity in the law or some sort of factual reason why the parties can't resolve their dispute by reference to what was in the contract. In that case, we can assist with litigation. What I would say though is that it's always important to weigh up the benefits of trying to find a compromise, even though it might not be the best result, rather than running the matter through to litigation. And one of the main reasons for that is that litigation is expensive. There are high stakes once matters proceed to trial. Courts have a very wide discretion to award costs in favour of the parties who are in the dispute. One of the general principles is that the winner of the dispute is entitled to have their costs paid by the losing party. So what that can mean is that if the parties are fighting over a sum of money, and let's say it's $100,000, the court might award one party to receive that $100,000 in damages, and on top of that $100,000 that has to be paid by the losing party is also ordered to pay $25,000 of legal costs to compensate the winner. Now that is on top of the losing party having to pay their own lawyers. So all of a sudden, what starts out as at first blush a $100,000 issue can become a $200,000 issue without much difficulty. The costs scales in the various courts set out a benchmark for legal costs. Lawyers can charge above or below the scale. Our firm charges below the Supreme Court scale, but there are different areas of complexity for costs. So one of the problems with litigation is that the longer it goes on, the more costs are incurred, and that will become a factor for parties as they decide how to conduct themselves in the litigation. The other thing, of course, to remember is that sometimes you can have a situation where you think you have an outcome at the end of a trial, and then an appeal is lodged and it happens all over again. So if anyone's got concerns about the costs of legal proceedings, it's something that I'd be happy to talk to them about, and we pride ourselves on giving really open and transparent disclosure on the costs of litigation. As I say, sometimes litigation is unavoidable, and in that scenario you need to be prepared to bring the best resources you can to give yourself the best chance of success in court. But I always say to people, think really hard about whether there's a compromise that you could live with, because I'd rather that you avoid the stress and the cost of litigation if you can, and get the certain outcome of a settlement that's negotiated on terms that you're in control of.
Right, Lucy, thanks so much for taking the time to tell us about some of the issues relating to commercial contracts.
My pleasure.